The Sixth Circuit Court of Appeals is making a lot of people mad right now. After last week undoing the federal ban on bump stocks, they decided to take it a step further and allow a Christian college professor, not a professor at a Christian college, but a college professor who is Christian, to sue his employer, Shawnee State University, over their demand that he, quote unquote, respect a transgender student's pronouns. He refused to use the transgender student's preferred pronouns and was sent a warning letter over it. He says that's a violation of his free speech. The district court in this case threw it out. They said, nope, you don't even have a right to sue over this. That doesn't count. He appealed that, and the Sixth Circuit said, no, he does have a right to appeal this. This might be protected free speech. This is a matter of public concern, and it's hotly contested, so he gets at least the opportunity to show that this letter violated his free speech rights. And this is a doozy, so stick with me. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. If you like that type of stuff, go ahead and hit the subscribe button, hit the notification bell, and don't miss any videos. Okay, so this story is from Fox News. You can find it really all over the place. A bunch of publications are really mad at the Trump judge who wrote the opinion, but this is an appeals court. So this is a 3-judge panel making this decision. You can find a link to the Fox News article down below if you want to read it. We're going to take a peek through it though. And like I said, you can find this story all over the internet right now. But here's the headline. Ohio Christian college professor who rejected transgender students' pronouns can sue the university. Court rules. Trump appointed judge argued Nicholas Merriweather was punished for communicating a hotly contested matter of public concern. And those are some of the magic words invoking First Amendment protections. It's important to note that this is Shawnee State University. This is a state school in Ohio, and that means they have the same requirements that any other government institution has in protecting First Amendment, in respecting the First Amendment and offering its protection, and really every other amendment as well. I mean, they're bound by the Constitution as they are a government entity, and their employees and agents are acting on behalf of a government body. So if they want to restrict speech, they have to follow the same sort of level of scrutiny that any other institution would have to follow that was government. So here we go. A federal appeals court ruled on Friday that an Ohio college professor can try to prove his First Amendment rights were violated and sue the school for damages after he was reprimanded in 2016 for refusing to address a transgender student by her preferred pronouns. And if you are not aware, this is a male to female trans. So their preferred pronouns are her, she, her. It was, biologically male, if you want to look at it that way. I personally don't care where people fall on the transgender issue. This video isn't a commentary on that at all. It's merely a commentary on what speech is protected and what compelling speech leads to. I think compelled speech by a government institution is exceptionally dangerous. This judge happens to agree with that. According to the 6th U.S. Circuit Court of Appeals, Nicholas Merriweather, a philosophy professor at Shawnee State University, argued a new rule by the university requiring faculty to refer to students by their preferred pronouns did not reflect biological reality and contradicted his devout Christian beliefs. So these beliefs actually could become an issue in the court case as it proceeds, because he may have to show that his beliefs are deeply held and that his activity in this issue is consistent and not being discriminatory against a person or a group. That will probably be part of this lawsuit as we go forward, but that remains to be seen. So let's see, a student in Merriweather's class referred to as Doe complained to university officials that Merriweather's repeated refusal to use the student's feminine pronouns created a hostile environment in violation of the school's non-discrimination policy. Now, the union, I'm going to summarize the next parts. The union went ahead and filed a grievance on his behalf, and the school agreed. This was not a hostile environment. He didn't do anything to create a hostile environment. However, they found that his refusal to use the preferred pronouns amounted to quote unquote different treatment, and that different treatment was discriminatory, and therefore the warning letter that he received was justified. Now, this is pretty important because discrimination tends to have some sort of adverse result to the party. A hostile environment is an adverse result that's recognized by law. Different treatment can lead to a hostile or a hostile environment or some other adverse result, but it doesn't automatically follow that it does. And so that is going to be part of this was his differential treatment, if that's a true thing. First of all, was it even real? Was it even differential treatment? And then second of all, did that differential treatment lead to a negative result? They've got some problems with that coming up. Out of options, Merriweather pushed back with a lawsuit alleging he cannot address a high-profile issue of public concern that has significant philosophical implications, that the warning letter will make it difficult, if not impossible, for him to obtain a position at another institution once he retires from Shawnee State. The Trump-appointed circuit judge Amul Thapar, I don't know how to pronounce that name, argued in a 3-judge panel's ruling that Merriweather was punished for communicating a hotly contested matter of public concern. He also said there is no suggestion that Merriweather's decision to avoid using feminine pronouns impacted his duties in the classroom, hampered the operation of the school, or denied the student any educational benefits, noting Doe was given a high grade. So where's the harm? That's what the court's looking for here. Where's the harm? Not harming the school, not harming the class, not harming the student. Where's the harm? Just being offended is not harm. It may feel hurtful to you, and I do apologize for your feelings being hurt, but it is not actual legal harm to just be offended. You don't have a right to be free from being offended, and you don't have a right to be free from taking issue or umbrage with someone else's speech. That's the whole purpose of free speech, is that you may have to take umbrage with it. You may have to disagree with it. You may have to disagree vehemently with it. The only thing we ask is that you please don't disagree violently with it. That's about it. But you get the right to challenge, to go after someone's speech and say that it's not correct and that they're an idiot, whatever you want to do. They're bigoted. You can say all these things. You don't get the right to shut it down. And that's the important part. And maybe even more appropriately, the government doesn't get the right to compel you to say something that goes against what you feel or believe. Compelled speech is a very, very dangerous ground. And that is where this judge has really focused in on this. So here we go. If professors lacked free speech protections when teaching, a university would wield alarming power to compel ideological conformity, the judge wrote. A university president could require a pacifist to declare that war is just, a civil rights icon to condemn the Freedom Riders, a believer to deny the existence of God, or a Soviet emigre to address his students as comrades. That cannot be. By forbidding Merriweather from describing his views on gender identity, even in his syllabus, Shawnee State silenced a viewpoint that could have catalyzed a robust and insightful in-class discussion, Thapar added. The lawsuit has been returned to a Cincinnati judge who dismissed the case in February of 2020. And that is the main story. The lawyer for the Alliance Defending Freedom, John Bursch, who, by the way, the Alliance Defending Freedom is out there actually doing a lot of this work. They're also, I believe, representing the Colorado baker in his cake ordeals. He has praised the decision, saying nobody should be forced to contradict their core beliefs just to keep their job. And that is a solid premise. It typically can only be applied legally to the government. Private companies, a private college can actually implement these compelled speech policies without the same sort of legal protections for an employee. The employees of state colleges, however, do have the full benefit of the Constitution at their back. The state is required to honor the Constitution as they are technically a government entity, and a state university is not immune from that. So Pretty interesting case. We'll be watching to see what happens. I don't know what the schedule is like on this case. Remember, this thing started back in 2016, so it is moving at we'll call it a languid pace. But we'll be watching to see what happens. Go ahead and drop a comment down below. Tell me what you think about this decision, about this judge, and we'll talk to you next time. Peace. Peace.